So good afternoon and welcome to the Deason Center's revamped student programming series we're calling Deason Discussions. This afternoon's presentation features Attorney Russell Wilson discussing a very hot topic in criminal justice reform, the use and misuse of no-knock warrants. For those who have not yet met me, my name is Kenitra Brown. I am the staff attorney and engagement coordinator at the Deason Criminal Justice Reform Center housed at SMU Dedman School of Law. The Deason Center was established in a law school in July 2017 under the direction of Professor Pamela Metzger. The center brings a stats and stories approach to criminal justice reform. We use stats to emphasize the stories of real lived experiences of justice-involved people to make compelling cases for criminal justice reform. We tell these stories through research, education, and advocacy. While our primary areas of research concern prosecutorial discretion, public defense, and small tribal and rural justice, our engagement agenda recognizes that we don't and can't do our work without recognizing the expansive mission of transforming the criminal justice system and other structural systems it interacts with. And so it includes conversations about salient criminal justice issues in the national or public discourse. Given the current climate, we want our Deason Discussion Series to not only engage law students as future lawyers in these important discussions, but to include other students and other interested members of the university community. Lawyers are change makers, but everyone has a role to play in learning about these topics and applying these lessons to their daily work and discourse. I'd like to remind everyone that we're recording this presentation. We encourage engagement, but if you have questions, please hold them until Mr. Wilson finishes his presentation, or place them in the chat. Please listen to learn, be respectful and thoughtful, and be mindful of your comments since this is technically still a public forum. And now I'd like to formally introduce Attorney Russell Wilson II. Attorney Russell Wilson II began his legal career in Dallas after graduating with honors from the University of Oklahoma College of Law. He formed his own practice with a focus on both civil and criminal matters. His early professional goals were to meet the needs of the average member of the community and provide top-notch legal representation to an underserved clientele. Russell has been board certified in criminal law for over 15 years, and in that time, he has successfully argued a variety of state and federal cases at the trial and appellate levels. In 2011, after building a highly successful private practice, Russell was handpicked by the Dallas District Attorney to direct Dallas's Conviction Integrity Unit, one of the first of its kind in this country. Russell demonstrated additional leadership during his tenure at the DA's office as he jointly managed a 500-person department and spearheaded the successful exoneration of 13 men. The Dallas Conviction Integrity Unit was responsible for the highest number of exonerations in the country in 2011 and 2012. Russell was also in charge of civil rights proceedings against police officers, contempt charges against prosecutors, and review of police actions and misconduct. Subsequently, under Russell's direction, a civil rights unit was established at the DA's office, which implemented several policies to ensure accuracy in criminal convictions. His work at the CIU also led him to work with the Innocence Project and consult with other state agencies and nonprofits, furthering his skills and experience to successfully review and manage wrongful conviction cases. His time at the DA also propelled his community relations work between the community and law enforcement, with an emphasis on justice and civil rights education, as well as promoting citizens' critical awareness to prevent injustices in all forms. After his service at the DA's office, Russell returned to private practice where he continues to work on a variety of civil and criminal cases. In addition to his legal practice and community work, he is also an adjunct professor of law at this law school, SMU Dedman School of Law, where he teaches a course on ethics. He holds several board positions and is a frequent guest speaker on criminal law topics, community policing, and the importance of higher education. And with no further ado, I'll let Russell take it from here.
Thank you for that beautiful introduction. It certainly reminds me it's odd to now be coming up on my 25th year of practice. It's an honor to be here at the Dedman School of Law, the Deason Center in particular, and to be able to talk on this topic of the use and misuse of no-knock warrants. I do have kind of a PowerPoint presentation to take us through, and this discussion is intended to stimulate thought from the audience and certainly participation as well, but thought about some of the concepts that surround no-knock warrants and how they actually came to be used and what some of the issues are that we're seeing. Certainly the most salient one right now is BREONNA Taylor, but as the presentation will show, the issues surrounding no-knock warrants has been around for some time. And it's now in a year of substantial criminal justice reform that we're actually trying to see this issue come back to light. And so I'm going to present in a way to try and address questions. There'll be some video clips that will show a variety of examples. With the notion of criminal justice reform, probably one thing to just have in mind isn't to attack any particular group. It is really grounded in the notion that we as a society can continue to improve on what we do in the same way. Yesterday, the new iPhone came out, and each year, even if you've done decent with the iPhone, Apple comes out with another iPhone trying to improve on what they've done. And so part of the criminal justice reform, and certainly my view is that as practitioners of criminal law or being engaged in the practice of law, we should also always strive to improve upon what we have done in the past. And so the purpose of this discussion is to stimulate a discussion on those issues. Let me go ahead and take y'all to the PowerPoint and we'll get started here. So one of the first things that I thought about for our discussion was, just kind of throwing out just general questions maybe that we're hearing from not only our colleagues, but just people in general, certainly in the community now. The core question regarding no-knock warrants is the societal value of seizing drugs higher than the value of the individual life of a target suspect? That would be the person who we're trying to necessarily arrest. A police officer, B, and C, an innocent bystander. And these three categories of individuals are chosen because, as you'll see in this discussion, all three of those categories have been killed in the execution of no-knock warrants. And so the question overall that I want our audience kind of pondering in the back of your mind is going to be, where do we draw this line at when we decide to enter a person's premises, and in what circumstances should we do that, and is it fair for us to do that as a society? And what have we learned from the past? So, other questions? Can strangers kick in your door and kill you for defending yourself? Can the police kick in your door and kill you for defending yourself? If they do not knock and announce, how would you know who it was kicking in your door? In this question regarding self-defense, can a police officer who is shot while executing a search warrant defend his or herself by returning fire? And can a citizen shot by a police officer executing a search warrant defend themselves by returning fire? Those are the questions that I think surround this issue. And one other question that we'll hopefully be able to touch on is there a difference, and should there be, between law enforcement's response to a barricaded person and an execution of a no-knock warrant? So I've packed kind of a lot of stuff in there, and I'm hoping that some of these questions stimulate some thought on these concepts, and it'll be a discussion that I know we're not going to be able to finish here today. But let's start out just kind of with how do we get to the no-knock issue. And recall that the Fourth Amendment protects everyone in the United States. A person has a right to be secure in their home, and the home is the target of the Fourth Amendment, the biggest privacy area that we have. And so that was the whole reason that created the need for search warrants to begin with. It was that without probable cause, you couldn't enter a home for the purpose of conducting a search. And this, if you go back, and if we got our constitutional folks here, they'll go back way to prior to the Fourth Amendment, and its true origin was that searches were done without any warrants, without any probable cause in England. And so part of the passage of the constitutional amendments was, in fact, to limit the scope of the ability of the state to enter into a person's home. But before the Fourth Amendment, there was another amendment, the Second Amendment, right? And it dealt with the right of the people to keep and bear arms, and expressly says that it shall not be infringed. And you're seeing these issues, both of these issues today, really at the forefront. And they, in this circumstance, I think they collide. On the one hand, the person has the right to privacy in their home. The state couldn't enter without probable cause. On the other hand, the person in their home also has the right to keep and bear arms. It's constitutional. And so when we talk about constitutional rights in our free society here, we're talking about basic foundational type things, that this is our minimum guarantees. And certainly here in Texas, there's wide latitude with regard to the possession and carrying of firearms. One of the things that comes up here is this issue of stand your ground. And just briefly, I wanted you guys to be able to take a look at the number of states in the United States that actually have stand your ground laws. And those are the laws, of course, that one, for example, in Texas, is going to give you a presumption that you're justified in shooting and killing anybody who tries to enter your home in the evening. Now, that anybody doesn't necessarily apply to the police, but there's not also a limitation there in the statute. And this gets into the whole issue regarding no-knock warrants. But if we look at our states as a whole, even if we look at our statistics regarding the number of Americans with firearms compared to other countries around the world, it's fair to say that in general, we are perhaps the most armed nation in the world when it comes to the citizenry of the nation. And so when you set kind of the backdrop for no-knock warrants and the privacy interests in a house, and the fact that it's reasonable to believe that the majority of houses, or a strong number of them, will have individuals that are armed, that's kind of setting the framework for this issue of no knock. So let's talk a little bit about some of the Supreme Court cases. First of all, Arkansas v. Wilson, 1995, unanimous decision. Supreme Court comes out and they say, you must knock and announce your presence prior to executing a search warrant. So that the knock and announce requirement goes way back to common law. And if you think about it, it's kind of just like if you close your door to your bedroom or to any room in your house or to your front door, that, the general expectation is that a person knocks and waits for you to come to the door. The Supreme Court in Arkansas v. Wilson wasn't saying that should change any if the officers were executing a search warrant. So a search warrant standing alone was not a sufficient reason to not knock and announce. In fact, there was an expectation that you would, in fact, knock and announce. Well, when can the police eliminate the knock requirement? 2 years later, we get Richards v. Wisconsin, Supreme Court case as well, another unanimous decision saying in order to justify a no-knock entry, the police must have a reasonable suspicion that knocking and announcing their presence under the particular circumstances would be dangerous, futile, or would inhibit the effective investigation of the crime by, for example, allowing the destruction of evidence. Make a note to yourselves right here, because we're going to come back to this this particular decision in particular, because there wasn't a weighing of the threat to the person in the home. There wasn't a life versus property weighing, which I think is kind of the direction that this discussion is now going, which, you know, here the Supreme Court was saying exclusively inhibit the effective investigation of crime. How long do you have to get to the door after the police knock and announce? This is also, I think, an important point here. And the Supreme Court, 2003, they outlined basically that 15 to 20 seconds without a response, the police could fairly suspect that cocaine would be gone if they were reticent any longer. Now, whether this is long enough or not, you know, we could talk about for some time, but the reality is this: when we start talking about no knock, this case here has held, this is a knock warrant. This is 15 seconds after knocking that the police were permitted to enter, and the Supreme Court held, even though they thought it was a closed case, they unanimously held that that was a sufficient amount of time. So part of whether or not a search warrant is reasonable in its execution is the length of time after knocking and announcing presence prior to entry. At least that's what we used to have as the, I think as the standard. You know, there's certainly other cases that have impacted that since then, but in general, the law was 15 to 20 seconds after a knock, you could go in. This is significant because when we talk about no knock, we're saying not even waiting 15 to 20 seconds. We're saying no delay at all. And that is, when you talk about eliminating no knock, this is an elimination of a search warrant. It's not even elimination of anything except this, you know, it's really kind of codifying this delay, if not perhaps a longer delay in any given circumstances. So as these cases came down from the Supreme Court, what we saw was more and more often raids being conducted by police, oftentimes no-knock raids. And here you see what I'll call the slammer. And you also saw a proliferation of flashbangs. And flashbangs are important in the discussion here because they are often employed in no-knock warrants. So in other words, what you see is a door kicked in or knocked in, and then you almost immediately a flashbang grenade goes off. The literature surrounding these flashbang grenades is that they are specifically designed to disorient the person that is, you know, in proximity to them. So this video just has a few different demonstrations or clips of what flashbang grenades look like, perhaps what they sound like if your sound is good as well. And so let you guys take a listen and look at this here. Big out! Um, you can certainly see from the videos that a flashbang certainly would be or could be disorienting to the folks in the house when it goes off. It can stun them. Importantly for our discussion, deploying a flashbang also impacts a person's hearing and their awareness. And that'll, I'll bring that up a little bit later here as we talk a little bit more on this. So historically, I said this isn't the first issue. We're all aware, of course, the Breonna Taylor circumstances and situation. And we'll touch some on that as well. But way back in 2007, this was one of the articles from D Magazine, the Friday morning rant showed as the police as home invaders. This was an issue that came up then. The family of a girl who shot at a SWAT officer doing a pre-dawn raid on her home is saying she thought it was a burglar. Hard not to give that claim some credence when police start using the same tactics as violent home invaders. How do you tell the difference? This was a journalist with the D Magazine in 2007 posing this question. And so I say that to say this issue has been around, I think, for some time. 2009 in Dallas. I've practiced here for 25 years. In 2009, a well-known corporal in Dallas, Norman Smith, he was shot and killed during a no-knock raid. And the police chief says the officers were serving a warrant, attempting a ruse to try to get the suspects without announcing that they were police officers. And this ended up in the officer's death. It was a huge loss for the Dallas community. It was a huge loss for the law enforcement community. And this is an additional question that we'll be, again, revisiting here. What exactly does it take to get to a no-knock warrant? What are the circumstances that we're seeing? Here I have the language, the exact language in the Breonna Taylor search warrant pulled directly from the says these drug traffickers are fine as requesting a no-knock entry due to the nature of how these drug traffickers operate. These drug traffickers have a history of attempting to destroy evidence, have cameras on the location that compromise detectives once they approach the dwelling, and have a history of fleeing from law enforcement. So collectively here, you don't actually see in this particular warrant things that I think are actually specific to it's saying these drug traffickers, but as I read the body of this warrant, I believe they're saying drug traffickers in general. There wasn't specific instances. And for example, you'll notice in this particular situation here, cameras on the location that compromise detectives once an approach to the dwelling is made. And when you see that, your mind may go right to your Ring doorbell cameras, your regular cameras that any person may have on their home, generally designed to increase the security of your home. Here, you can actually see that they could be, in fact, used to justify a no-knock approach. One of the odd things in the Breonna Taylor case was it did not actually appear that there were cameras outside of her door there on her apartment. And you also would note there wasn't, for example, an allegation that Ms. Taylor herself had a history of fleeing from law enforcement or any of these types of things, which you might have expected to see in general in a no-knock warrant. Here's an example of a circumstance. This is, again, another one occurring. So you had the D Magazine article. I'm gonna jump forward. You then had Norman Smith. Here's a actual body camera from Fort Worth and a circumstance. And let me just play this video for you, and we'll also be able to talk about this some more at the end here.
Let's
So in that situation there, Darden, the obese man that was inside of the home, actually died as a result of the autopsy, I think, indicated the restraint and also a heart attack. A couple of things, you certainly saw the no knock though at the beginning of the video, and the storming, if you will, into the home, which is I think often indicative of the no knock warrant. There's another situation. This isn't the only one. This was another one from the New York Times, also another Texas case. Another officer was killed in this circumstance here. They were attempting to raid a home, and New York Times covered this in depth in 2017, talking about, again, the use of no-knock warrants and the risk that were posed to the officers in execution of the warrants. Again, this is the language in that particular case. The informant has reported that guy is frequently armed with a handgun, accompanied by other individuals, both known and unknown. And it's not uncommon for individuals who deal in large quantities controlled substances to employ others to sell or protect their illegal substances and proceeds from these sales. Affiant asks that this warrant be issued authorizing a no-knock entry. And here's the judge says, I further find that the fine established sufficient reason to believe that to knock and announce their purpose by the officers executing the warrant would be futile, dangerous, or otherwise inhibit the effective investigation of the offense. And so he authorizes them to go without knocking. This results in an officer being shot and killed. And I think in this particular case, there was slightly over 4 ounces of marijuana that were recovered. When 4 ounces is significant, because less than 4 ounces was a misdemeanor offense. 4 ounces, I think 4.6 in that case. Texas isn't the only area. We've seen this issue kind of nationwide. Last year, this was a News 2 report of Chicago running issues that they had as it related to the use and execution of no-knock warrants.
Chicago police changing how they conduct search warrants after an 18-month CBS 2 investigation exposed officers repeatedly raiding innocent families' homes.
Yeah, the mom of these children says it's not nearly enough. CBS 2 investigator Dave Savini showed her newly uncovered body camera footage of her bad raid.
It's 8:30 at night. You're inside a police car on Chicago's South Side. A team of officers zeroes in on a house. 14 heavily armed cops on the hunt for a heroin dealer with the street name Peanut.
Did anybody knock?
No.
They just came in?
Door's open. Go in, watch the right. But they are breaking into the wrong home. And all they find are innocent children.
They had guns to our face.
14-year-old Savannah in the purple shirt hits the ground. You are looking at the back end of a high-powered rifle. Lying next to her, still in his school uniform, is her 7-year-old brother, JJ. He was stunned at the sight of an assault rifle.
And they had their finger on a trigger.
In another room, their 11-year-old sister, Talia, is face down, surrounded by more weapons. Their mother, Crystal Archie, watches for the first time what happened to her children. She was on her way home from work when the raid happened back in April of 2019.
Relax.
Please do not shoot me.
You're fine. You know who's on the floor right there? Can you tell who's on the floor?
My daughter is on the floor. I can hear her. I can hear her yell. I can hear her yelling. And you just see the guns at the back of her head.
Her oldest child, Savannah, was babysitting.
Come on, get up.
They're handling heavy artillery. It would have taken one slip of your finger, and my children wouldn't.
And even this past year, I think it was actually earlier last year when we saw the raid. There was a raid in Houston that ultimately resulted in the death of 2 of the individuals inside the home, and 5 officers, I think, were shot or injured in that raid. Ultimately, 6 officers were charged with crimes related to that raid. Take a listen to this.
I don't trust being in my own home, near that home, because I don't know if someone's going to knock down my door.
People are furious, and they're letting the police chief of Houston know it after a botched drug raid last month that killed a husband and wife in
June of this year, the city of Houston mayor actually entered a proposal regarding no-knock warrants. Not just a proposal, he signed an executive order. The police officers are prohibited from executing a no-knock warrant unless the warrant has been approved in writing by the Houston Police Department, chief of police, or his designee, and the warrant is signed by a district judge in accordance with HPD policy. This was a dramatic change from the prior practices in Houston regarding no-knock warrants. It made it actually a little bit more difficult for no-knock warrants to be issued in Houston. It also required body-worn cameras will be used by all officers who are members of the entry and perimeter team serving a no-knock warrant. As you know, the whole issue with body-worn cameras is to document with as much specificity the events as they are actually unfolding. But this is a reform measure that's has taken place in the city of Houston. Of course, Houston is our most populous city in the state of Texas. So it's our largest, this is probably the order that has the largest impact on Texas residents. San Antonio shortly thereafter has also followed suit on this issue. And if you listen to this clip here regarding what was going on in San Antonio related to no-knock.
Thank you. And San Antonio police have suspended the use of no-knock warrants, something that many people are calling to be banned permanently. Eyewitness News reporter Jordan Foster spoke with a San Antonio community activist working on making that a reality.
San Antonio Police Chief William McManus says right now the use of police no-knock warrants have been suspended.
Our local government, our law enforcement, our city council, they all knew that we needed a win. We've been out here protesting consistently for over 8 weeks.
It's the type of change Jordan Joe Parks, along with many other community activist groups in San Antonio, have been pushing for.
When you use a no-knock warrant and you bust in there, in your mind, you are justified as an officer to do that because you got the warrant. In a civilian's mind who is sleeping in their bed or who's playing video games or who's enjoying their day and had no idea you were coming, if you bust in their house, in their mind, they have the right to protect their home.
Breonna Taylor was shot and killed in March by a Louisville Metro police officer after they busted into her house while serving a controversial no-knock warrant, something people across the nation are still protesting. Chief McManus gave us this statement telling us why he made the decision. He says the decision to suspend the use of no-knock warrants was made to better protect the public and officers. Reducing the potential for serious bodily injury or death outweighs the need to recover illegal drugs or contraband.
So it is a risk for the officers' lives as well. So there should not have been a negotiation there. It shouldn't be a suspension. It should have been a full ban.
Thank you. And Senate.
And of course, this kind of leads to the overall question is that should we, as a society, ask police officers to execute no-knock warrants for the purpose of recovering physical items, i.e. drugs, guns, any property or tangible object? And you saw there in the San Antonio chief of police that the quote was that the need, in essence, to preserve life outweigh the need to recover the drugs. And I think that is at its very core the issue here is should we continue on this? And is it something that we should ask police officers to do given the impact that it's had not only on the police, but the citizens, and in the case of Breonna Taylor, obviously the innocent bystanders. And I think it you know, the proposal or the thought to throw out there for discussion is eliminate no-knock warrants, which, as you go back to that case regarding the 15 seconds, that's the core of what we're talking about being eliminated. You're not necessarily talking about elimination of a search warrant, but eliminate them in general. No-knock warrants. Force entry only after a meaningful opportunity to come to the door, and immediate entry only in immediate life-threatening hostage or barricaded person situations. And so if we shift the approach to no-knock warrant to these circumstances, you know, would we expect that we still could, one, prosecute drug crimes, but we could do it in a safe way? The only other thing that I kind of add to this proposal is that there are a wide variety of law enforcement tools that allow for the apprehension of suspects without the necessity of no-knock warrants. Everything from tracking devices to confidential informants, but there's a wide array of tools. And so the proposal to eliminate our suggestion that we could eliminate no-knock warrants is not by any means an avenue that would allow these individuals, to the extent they have engaged in some type of wrongful conduct, to avoid any consequences for it at all. You know, the opponents to this may say, well, there is the possibility of the destruction of drugs. And we saw that really in the Supreme Court's opinion, that it wasn't life of the person wasn't being put in issue. It was in essence the value of being able to recover the target item. And you know, the chief of police for San Antonio there is weighing those two different issues and siding on the side of doing what is best to preserve life. And so I think we do have, in fact, not just with the Breonna Taylor case, but with historically a number of cases, not just in Texas, but really nationwide in major police departments, where the body of evidence on this issue tends to weigh heavily, if not entirely, toward the elimination of no-knock warrants or the dramatic reduction of their use, and perhaps the increase in use of other methods of surveillance or other methods of apprehension. So that is the discussion kind of portion here that is aimed at trying to target you know, the framework of what we have going. And, you know, what I can do is go back and answer some of the questions. I know that I believe we're going to have questions through chat. I'm not necessarily positive how we wanted to start with the questions, Kenitra, but if you want to let me know on that. I see we've got some folks raising hands, and
Yeah.
however we want to do that, then I'm happy to oblige.
Okay, guys, before we get started, thank you guys for the chats, for your engaging, for already starting to engage. Before we start the Q&A, I want to acknowledge that I probably should have given, for those of us that are on the call, I should have probably given a trigger warning.
Oh, yeah.
I know some of those images were difficult to watch, particularly for a few people on the call. So that was an oversight on my part. I knew that was coming, and that was a short sight, so I apologize. So we'll start with the questions that are already in the chat. If you ask the question, you can let me know if you want to say it, if you want to ask it out loud, or I can go ahead and ask. The very first question that we got was from Emily F. And her question goes back to, is the camera alone enough to grant a no-knock warrant? Or is the presence of the camera alone enough to grant a no-knock warrant?
You know, Emily, so it gets granted kind of on a case-by-case basis. A judge is, in essence, asked to sign off on that. In my view, a camera alone would not necessarily be enough to grant a no-knock warrant. But you've got to think that there's also going to be, in conjunction with the request for no-knock, is going to be whatever the facts and circumstances are for the probable cause. So what you're seeing is a camera plus the fact that generally a person engaged in the sale of narcotics may be armed. And unfortunately, we're seeing, I think a lot of judges find that that's sufficient. You know, if we get really into our Fourth Amendment stuff, there was a unique specificity requirement of the Fourth Amendment. It was really designed to avoid what we call general warrants, which is where you just kind of can generally go in. But it hasn't played out that way as it's related to the no-knock requirement. And so I think a camera plus probable cause, I have seen that. I can tell you I've seen a situation where a person had a picture of themselves with a firearm on Instagram, plus they had a camera, and that was enough to get a no-knock warrant. Let's see.
Mr. Ehlert, do you want to ask your question out loud, or do you want me to do it? I'm going to go ahead and ask because I haven't heard him. Bob Ehlert asked, is there data showing the effectiveness of no-knock warrants in regarding to arrest and prosecution? Is there data on the settlements of civil suits against police arising out of no-knock warrant use?
Well, Mr. Eller, I don't have that data, but I'm glad we're at the Deason Center, which is data driven. The reality is this, that it's not easily, it is likely easily tracked, but it's rarely done. The police department search warrants are public record, but I don't know that, we go down and so, how you track the effectiveness versus not using them. What I can say though, for example, in Houston or San Antonio, you haven't seen an uptick, if you will, in in crime by eliminating the use of the no-knock warrant. So you're really, I think, saying, hey, if the true target is not to avoid the destruction of drugs, honestly, that is a risk. The police chief in San Antonio certainly acknowledged that was a risk. And so I don't know that you'll necessarily weigh the effectiveness. I think effectiveness would be if we stop seeing innocent bystanders killed, we stop seeing officers killed, and we stop seeing the targets of warrants killed. That would really be our measure of effectiveness. And so it's kind of like the FAA, because one person may also say, well, there's a number of no-knock warrants that are done without incident. When we see plane crashes, any one plane crash we say is too many. And we have an entire agency that investigates and reviews plane crashes to ensure that none happen. They aren't successful, but certainly planes are way safer statistically than cars are as it relates to whether or not you're likely to crash and die. And I think that our approach in criminal justice has to be the same way, that we want to use methods that we believe give us the greatest chance to protect life over property. But I don't know of data. And you also asked about civil suits. I did actually have a client, so I've participated in a suit where we sued the city of McKinney. My client was inside of a home. The police came to raid the home. They threw a flashbang grenade. The grenade landed on a couch and detonated. It disfigured his arm permanently. He was just at the home visiting. So again, I don't know the overall number of settlements, but I do know that the cases do consistently arise.
Caitlin, your hand is up. Do you want to ask your question aloud?
Yeah, I can go ahead and do that. Can you guys hear me okay?
Yeah, I can hear you.
Perfect. First of all, I just wanted to thank you guys for this webinar. It's been fantastic. And I also wanted to note, Mr. Wilson, that your comment about the plane crash really resonated with me, because a lot of times I think about the comparisons that can be drawn between, like in the airline industry, we can't have bad pilots, right? You can't have bad pilots. There's too much at stake. And I absolutely agree that it's the same with the criminal justice system. You can't have bad cops. You can't have bad prosecutors and things like that. There's just too much at stake. But my question goes back to the no-knock warrants. So I know that a number of jurisdictions have suspended them entirely, but areas where they've just, made provisions attempting to make the no-knock warrants safer by making them more difficult to obtain. So like a higher burden of evidence needed to obtain them. How do we deal though with the issues associated with judicial discretion when it comes to that? Or is there a way to deal with that? Because I know that that was a big issue in the BREONNA Taylor case and in so many other cases. And so I guess the final question is it possible to fully eliminate like misuse of judicial discretion in allowing or not allowing these warrants? Or do you think that the only effective solution is to eliminate them completely?
Right. So Caitlin, I think, one, I appreciate your comments. And then two, I think this is a great question. The true vehicle right here is likely going to be the states, right? If we thought of how our government is structured, Fourth Amendment is federal level, and so certainly we could see federal action on the issue. If you go down, each state could certainly pass its own laws related to it. Then if you go down from a state, you go to a county, and then you go to a city. But what you start to see is a variation in the enforcement. So for example, the citizen in Houston may not be subjected to the same requirements as the citizen currently in Dallas or Fort Worth. And so depending on the legislative level involved, and my suggestion is it's likely going to be at the state level. There was a congressional briefing on this issue of eliminating it altogether. And if it's eliminated altogether, then there is no judicial discretion. But, you know, congressional gridlock and legislative gridlock in each city's formation. So in Houston, you see it that's an executive order from the mayor. In San Antonio, it's a directive from the chief of police. So there's different avenues, but unfortunately that results in continuing inconsistency.
Great, thank you so much.
Let's see, next. Next question.
Sorry, I was having difficulty coming off of unmute. There's a question from Edna Hargraves. She'd like to know how one can claim self-defense when the person that was killed didn't have a weapon.
No, that's a great question. So I think we have to look at kind of a broad scope of self-defense again at the state level. But you know, the question becomes if a person believes, you know, Texas has a lot of very broad laws, and their self-defense law doesn't actually even require that the person be correct. One of the areas where you've seen this come up most often is the situations where you've seen an individual shot and killed, perhaps by a police officer, and the officer may be able to say, hey, I believe that the person had a weapon. It turns out the weapon is a cell phone, or it's not a weapon at all. The way that the law is, you don't have to be correct all the time. You have to be, for self-defense, generally reasonable in your belief. And so if a person, and that can result in you being able to defend yourself against a person who, unbeknownst to you at the time, is unarmed. And so that certainly has happened before. Again, that's not our first time seeing it. But it doesn't have there's not a hindsight regarding self-defense, and that applies across the board, not just to police officers, but to citizens as well. And that was kind of the source of those first questions that I put out there to you, which was, you know, could a citizen shoot and kill someone entering their home? You know, I think we all would universally say yes. Then there was the other question, the polar opposite of it. Could the police officer executing a warrant shoot someone, you know, that shot at them during the execution of the warrant? And I think universally the law is going to say yes. And part of that discussion is, you know, and it gets to why do we as a society endorse creating that circumstance or situation? In other words, when we go into it, we know that citizens have a right of self-defense, and we know that officers also have a right of self-defense, and we are creating a situation where we do a no-knock, where these two rights are colliding. and it can result in the death of any person, the officer, the citizen that is the target, or the innocent bystander. And so currently the law doesn't have, though, a hindsight provision. So it's at the time that you're entering engaging in the conduct. And it's, you know, Texas is very favorable for self-defense laws, and that's the stand my ground stuff that I mentioned to you, and the Castle Doctrine, those concepts, which, you know, predate all of the stuff that is going on now regarding social justice.
I have a question that I'd like to come back to about the self-defense, but I want to ask one before we go back from Robert Denaj. He asked, why most, I don't see it anymore, but it's in my head. He asked why most,
no knock warrants are conducted at night or in the early morning.
Mm-hmm.
Again, Robert, I think this is a great question. And there's actually some case law regarding some limitations regarding conducting them at night. But I would imagine that the primary source of this is to try and get the greatest amount of surprise, if you will. And this is again targeted at trying to avoid the destruction of evidence. In the clip that I played from Fort Worth, I'm not sure exactly what time that was, but there was a few things maybe that you know, that were at least absent. It didn't appear, at least in the clip, that the officers had an idea of how many people were actually inside the house. The house had not necessarily been under 24-hour surveillance. Certainly in that situation, and in the one that we saw from Chicago, the fact that there were children inside of the house did not appear to be known to the officers entering. It certainly wasn't referenced inside of the search warrant, which would have also likely been something that, to the extent it was going to be used, likely should have been disclosed and certainly would have been fair to have known. But the timing of them, I think, is designed to try to to try to get the strongest element of surprise. And so early morning, everybody's asleep, but certainly at 1 or 2 in the morning, waking up the entirety of the neighborhood in the purpose of execution of a warrant. Again, regarding the seizure of property, even if it's drugs, some would argue is necessarily unreasonable, and then perhaps not in compliance with the Fourth Amendment.
I'm sorry, guys. I'm gonna use some privilege here and ask a question. I want to go back to the self-defense discussion. I can recall several years ago, well, not several. It was probably around 2014 or 15, a case right here in Texas where officers attempted to execute a no-knock warrant, and the person who lived in the house happened to be a Black man, and he did shoot and kill a police officer. He was actually charged with, I remember that he was charged with murder, and his charge was allowed to stand. Why is there that disparity where we realize, yes, you've got this right to protect yourself in your own home, and we might recognize that puts officers in danger, but then we punish people for exercising their right. So this Black man, he was, I don't believe, I need to follow up, but if I remember correctly, I do think he was convicted. I do think that his indictment and conviction was allowed to stand, even though there was a recognition that he didn't know that there was police officers actually climbing through his window.
So the dispute or the debate that comes up, and you even saw that some here in the Breonna Taylor situation, where the officers are saying we did announce our presence, and the boyfriend is saying no, we didn't, and there's a dispute regarding who heard what. The issue becomes, in order to convict the person, of the capital murder in Texas, if they shoot and kill the officer, you have to show that they know that the person is a police officer. And it really goes down to a case-by-case basis without knowing the specifics of the case and whether or not there was body camera rolling. There was recently a conviction related to the murder of a police officer in Richardson. In that situation, the person actually had barricaded themselves in. This occurred in Collin County. I think it was earlier this year, through Greg Willis's office. But I think it was abundantly clear, and part of the defense was I didn't know it was a police officer. In that situation, though, the person, I think, had fired shots. There were other situations, other circumstances that occurred before the shooting and killing of this officer. And, you know, it wasn't not a no-knock warrant circumstance. But one of the things that I threw out there to compare for a comparison discussion was the barricaded person approach, because the barricaded person is also a person who we know to be armed. We know to actually be a specific threat in that given situation. They may say, I'm going to kill the person I've taken hostage, or I'm going to kill myself, or there's a specific threat. And even in those circumstances, there's not a run up in and go in. It's usually an attempt to negotiate and get the person actually coaxed outside of the premises to surrender themselves. And that's why we have, you know, hostage negotiators and folks in that circumstance. So you get that comparison and contrast there, where when we do know specifically that life is at stake, from a policy standpoint, it seems we are more reluctant to go in without knocking and announcing. And the example for that's the barricaded person. And so, you know, again, the no-knock warrants, the primary targets are property, usually drugs, sometimes individuals. And, you know, if you think of, well, if it's an individual that you're looking for, then they aren't going to be able to, you know, the destruction of evidence isn't the concern then. If the purpose is to arrest the person, you know, you get into a lot of discussions of strategically whether it's better to wait and try and catch them in a car or at a gas station, or lots of other methods, again, to try to apprehend the person, as opposed to the no-knock, the entry into the home, which is the area you know to be, you know, heavily protected by the Fourth Amendment and the Second Amendment.
Okay, guys, we have about 1 more minute left. I want to be respectful of people's time. So I would like to entertain one more question before we adjourn today. Is there anyone else who has a final question that they'd like to ask aloud before we officially thank Mr. Wilson for his time?
Right. And, okay.
Oh, good.
I do see, let's see, I see Emily saying,
oh, I see it. Okay.
Right, that the police did announce their presence. And one of the things in that video, with, for example, the children in Chicago, was the amount of time. And, you know, you say, well, yeah, you did announce your presence. Well, sure, yes, you did. The amount of time between hitting that door and children on the ground was very brief. And that goes back to this notion of, did they have any meaningful opportunity to come to the door? And there's still a level of disorientation that occurs, I think, when someone, again, enters the home. It's not necessarily that you, the police, for example, aren't saying Chicago police. They may, in fact, be saying that. Because of the disorienting nature of the entry, the loud bang, the screaming and yelling, it's not necessarily clear that it's received in the same way, for example, as the barricaded person who's code over the loudspeaker or something like that, and called. So there's a contrast there that impacts, in that situation, the level of confidence and even the human situation that people in the community had in law enforcement. And so I think from a law enforcement perspective, the last thing you want to do is send a SWAT team in that puts children who are being babysitted on the ground. And you could never regard that as having been a successful execution of a warrant. And even if you announced yourself, but when you look at the level of risk to life that is being engaged in that situation, that is what has to be balanced. And so one person may say, hey, yeah, if you think the person's in there, that's worth it. Another person's going to say, no, you know, even if you think there's in there, maybe there's another way to do this. And so that is what this discussion is about, is how we approach these circumstances.
Russell, thank you so much for this presentation. Thank you so much for taking the time to create it, to talk us through this issue. I've been trying to get Russell to come and speak to us on the topic for months. This topic has been discussed in over months. It went from hot topics to this one, and his knowledge base is so expansive that I'm gonna put it out there right now while this is being recorded that I might ask you to do something else again soon. So I really appreciate the time that you took. The comments from you guys, thank you so much for engaging, for asking these thought-provoking questions. The body of research out there about the usefulness and the effectiveness of no-knock warrants is extensive. It's hard to tell where to start, but we will this is being recorded. The recording will be uploaded to our Deason Center YouTube page. And eventually we'll hope to use the resources that Mr. Wilson used in his presentation and offer those to you when we upload the video, so that when you, if you want to go back and watch, or if you want to have a place to start, we have those resources available eventually. We hope to get that done. Thank you guys so much for joining us during your lunch hour. Appreciate the engagement once again. If you have any questions about this particular presentation, or you have any questions about the center, you can email me at Kenitra, KENITRA @SMU.edu, or email the center directly at deasonjusticecenter@SMU.edu. If you have questions, I don't want to put this out there, but Russell, if you're okay with people emailing you about this presentation or any additional questions, you can either say your email out loud or feel free to put it in the chat. I know you're incredibly busy. If we also didn't mention that Russell still remains as a special prosecutor for Dallas County, so he's a defense attorney, but also still does work for the county. So you can imagine how busy he is. So.
Yeah, no, and I just dropped my email there in the chat, Russell@RussellWilsonLaw. You can hit me on Twitter. It's always an enjoyable thing to engage, kind of like I said, in the process of criminal justice reform, which is, I think, just continuing to improve. And so I like to have the discussions. I certainly think our law school and the Deason Center are going to be the future of criminal justice, well beyond my years. And so please continue the discussion. I'm happy to join it when I can and contribute when I can. But these are important issues that affect us all. And I just thank y'all for the work that you're doing, and please continue what you're doing.
Thank you so much. Thank you.
All right. You guys
Thank you guys. Have a good one.